With my Lord's permission, my Lord's mention item number 27 and 49.
Yes.
My Lords, these are those West Bengal matters. We had sought accommodation last week. Mr. Sibal is still unwell. He's leading me in the matter. My Lords, I was requesting for some further accommodation. The learned solicitor, we had informed him he's online.
On this ground, I cannot oppose. Subject to my Lord, Mr. Sibal's health, if it can be kept on 18th, subject to your Lordship's convenience.
18th February?
Yes, my Lord, 18th February.
Yes.
18th.
About 18th? Yes. With the consent of the parties, post both the matters on 18th.
I'm extremely.
18th.
Yes, 18th.
Obliged.
One.
About evening?
Lordship. My lords, may kindly see, this is an application I filed. The leave was granted in this petition on 14 to 24 by my lords.
Which matter?
The interim order.
Contempt की फाइल दो, सिविल अपील की फाइल दे दिए, लगा contempt.
Yes.
Yes.
Milords,
What is the contempt now?
Milords, what has happened is my lords were kind enough to initially grant status quo, then it was
the
confirmed.
orders passed by the High Court.
Yes.
That is at page 45 and 47.
Correct.
High Court says that both the parties did not bring it to the notice of the GRT.
Yes.
But I was not, Milords, unfortunately, the respondents were parties. I was not made a party also. Therefore, I went to the High Court.
But
Anyway,
but
the authority was not informed.
How is it a willful contempt? And ultimately, that order is appealable or amenable to challenge in law.
But Milords, my lord's order of status quo and leave being granted cannot be modified by revenue authority.
Mutation entry, it doesn't confer any rights.
Correct. I agree, Milords.
And
Milords,
our
when
orders will prevail.
Status quo is for possession only. What else?
Correct, Milords. Can I say this, Milords? Can I request this?
On ground, then you come.
Milords, can I
they
request like
violation
this,
of
Milords?
status quo by threatening to dispossess you
Yes.
or create third party interest kind of that, you
Yes.
come, we are not inclined.
Milords, can I say this, Milords? Can I request like this, Milords? Can this be kept along with the
No,
main
no,
matter?
no,
So,
it will not be kept pending.
Milords, then can I say this?
Counsel for the petitioner, we are
Milords,
not inclined
then
to
I'll
entertain
withdraw it
contempt
this.
petition.
Milords,
Yes.
I'll withdraw at this stage to
Yes.
raise my objections
Not
at an
this
appropriate
stage.
stage.
If today it is not contempt, tomorrow also it will not be contempt.
What are you?
No, if any,
He's same.
Okay.
Petitioner. If they do any other act which amounts to violation of our order, you are still free.
Always.
I'll withdraw on this ground, Milords. Lordship may say so, I'll withdraw on this ground because this is the revenue authority.
Current counsel for the petitioner seeks permission of the court to withdraw the contempt petition at this stage, accordingly dismissed.
Please.
Item 2.
Yes.
My lord, there's some delay in filing this. There's some delay in filing this SLP.
391 days.
Some delay.
There's a case.
Some delay is
Otherwise,
two figure, not three figure.
Group D employee, my lord. A case
Hmm?
of compulsory retirement, my lord.
Yes.
May see the charges, my lord. Charges are very simple, my lord. One day of unauthorized leave and
rude behavior, threatening, assaulting, abusing.
Everything, insubordination.
that I've given railway concession forms without permission of the principal.
And rightly set
1,000
aside.
rupees penalty is given, my lord. I was ready to pay the 1,000 rupees penalty which was imposed on the management. My lord,
It was rightly set aside by the High Court.
my lord, tribunal has exonerated by going through the
Tribunal acted as if the tribunal is the inquiry officer, which is not permissible and rightly said so by the High Court.
My lord, last submission, my lord. Before the learned single judge, the management was ready to settle the matter by offering me some amount, my lord. At least on that point, my lord, because today I have not
No.
received
You
any
should have done it.
benefits after 20.
You should have done it before the single judge. You should have done it.
Compulsory retirement, you will otherwise also get retirement benefits.
Until
What is
today, I have not
Dismissed.
received any benefits, my lord.
So that is a separate cause of action.
Dismissed. Delay control dismiss.
2580 days delay, sir. 2580.
Yes, sir. Well, the respondent number 1 is a post vesting.
What about the
Delay.
Well, it is a 7 years delay.
Only.
Not only.
There's a presumption that a man has died if he is not seen for 7 years.
I'm sorry, but the
You are also a juristic person. You also died.
changes.
Thank you. On the ground of delay. Dismiss on the ground of delay.
The delay. It is a settled law that the post vesting
By so and so.
purchasee cannot take the land.
Why were you
Why you
not
are-
cognizant enough?
And in
Everybody is
between,
sleeping.
in a dispute between the respondent number 1 and other respondents, why state should file a SLP?
Because the land was vested with the state in 1982.
No.
By the
Yes,
Sir,
next.
cognizant.
On the ground of delay. 7 years, who will condone?
Item 4.
Lordship, in this case, I'm a petitioners are the mortgagee. After that
You were never recorded as Bhumidhari.
Never.
Lordship, possession law is still
High Court says,
with us.
and all the authorities say possession is not with you.
Not with you.
Lordship, possession
That is
is with us. I can show the Lordship in this case what happened. No rejectment.
You are only a mortgagee. You are trying to
Step into the shoes
step
of the
into,
owner.
yes.
Lordship, I'll show. As on today also, there's a latest
There are
order.
4 concurrent findings, madam. This is 136. There's no
And
question of
see
it.
High Court's finding in para
6,
10 and 11
12 and 13 years.
that you are not in possession.
Lordship, this order is nowhere on the record.
High Court order is on record.
Lordship, not.
Dismissed.
Even
Dismissed.
in the high.
There is nothing, absolutely.
Fine. Lordship,
Yes.
kindly see the count. I'll
A
see the
mortgagee
order.
not in possession. Dismissed.
Item 5.
But
Yes.
no eviction, Lordship, I'm saying.
All right, then.
We are not saying anything. We are not saying
Customer
anything.
is not able to produce
We
it.
are not directing for your your eviction. If you are in possession, enjoy. Yes. Next. Yes.
13, 11 days delay, sir.
I must
17 days.
delay in filing the SLP news.
Yes.
Because the issue is the
Issue is delay.
yes,
Unexplained delay. That is the issue which you have to answer for.
And you are squatting over government land,
Plus,
Tamil
the delay-
Nadu land, and since long 1993, make way for the panchayat.
may I submit loss?
To manage the
There is
land.
a delay that 13 section title suit is still pending. Now there was an issue with respect to that judgment. Jaising
Dismissed on the ground of delay. Yes. Yes, go and fight it out. Water body,
Water
government
body-
wants to use it for public purpose.
I seek permission to withdraw the petition.
Yes,
Well
dismissed
advised.
and withdrawn.
Final order has been passed, and I seek liberty.
No liberty at all.
Final order has been, this
If you have liberty in law,
Final order has been passed.
now passed.
The counsel for the petitioner submits that since after passing of the impugn order by the High Court, the writ petition itself has been disposed of. Accordingly, he seeks permission of the court to withdraw the writ petition, withdraw the SLP, as it has become infructuous, with liberty to challenge the main order passed in SLP. Yes, accordingly dismissed with the liberty aforesaid.
Item 7.
Wait, please. The issue before the High Court was only seeking continuation of delay. High Court
Only,
says the allegation was-
only 8 years delay.
yes.
Only 8 years delay.
No, but what happens is this, he was suspended. After suspension, the termination order was never communicated.
Thank you.
Only one thing, Your Lordship.
Dismissed 8 years.
But Your Lordship, may please see this what they do is they initiate a formal inquiry. Formal inquiry is not even contemplated under that. Under the Act, they could have initiated department inquiry. There is no department inquiry. What they do is,
You should have challenged that order in.
Yes, next.
Item 8.
Very.
Wait, please, my lord. My lords, I'm aggrieved by the transfer order, my lord. Posted.
Don't work. You can resign.
Yes.
That option is always available to you.
My lords, I'm paying medical bills.
Absolutely nothing. Sorry.
You
I
have
will not entertain SLPs like this.
you have worked there for 6 years, 2019 to 25.
They Mitra, my lords.
Ah.
Then now, my lords, I'm transferred to Jashpur.
Yes. Puri is also in Chhattisgarh.
You have the option of resigning and continuing where as per your sweet will.
Yes, sorry. Thank you. Dismissed.
Item 9.
My lords, I'm paying a short pass over.
Which matter?
Item
9.
Item 10.
Your Lordship.
Yes.
The concurrent finding has been disturbed in revision on a mere assumption that there is some material on record, some material which the single judge says.
He has never been served. That is the finding of the High Court,
That's the
that the defendant was never served with the summons.
No, Your Lordship, we kindly appreciate this, madam.
What appreciate? You read the order.
Your Lordships may kindly consider, my lords.
And you participate and convince.
No, Your Lordships may kindly consider, my lords. The trial judge says serve. The appellate court serve.
Service by out mode was ever someone sent by ordinary process. Admittedly, no.
Registered courts, they were
No.
The CPC requires service through
First
ordinary
service
process.
through ordinary.
That
If it fails, then registered.
No,
From day one, you cannot serve by registered mode.
And the registered process is also refused. That is in your hands.
No, Your Lordships may kindly consider what Order 9 Rule 13 stipulates, my lords.
It is only at 40 degree you will
No, Your
still have
Lordships
the
may
chance to
kindly
prove your
consider
case
this, my
in the
lords.
trial.
Kindly consider this, my lords. Postal.
Dismissed.
Thank you.
Dismissed.
Postal state.
We don't encourage at 40 degree if the
State amendment
summons is
in
not
this.
served in accordance with CPC. Next.
Item 11.
Letter adjourned.
Item 12.
Item list.
Next.
Your letter, probably. You are not aware?
She announced immediately. Item.
Yes.
In the second provisional taking order,
What happened after the impugn order?
21/7/25. You have got opportunity to argue on charge, everything. You raise your objections at this stage of charge.
Notice was made returnable in 6 weeks by the High Court. What happened thereafter?
nothing has happened. No.
Nothing to go and convince him.
Go and argue the matter on merits.
Lord, page 47, if my lord may say.
You get a rejection on merit.
8%.
You get
In the
an
order,
on
in
merit.
the order under challenge in this SLP, the High Court has not decided any list or issue between the parties. Therefore, we are not inclined to entertain this SLP accordingly.
Lord, it will be rendered infructuous.
No.
Doesn't matter.
No?
Lord,
You always
my
have.
question petition would come infructuous, Lord.
You argue that and convince. Yes.
Item 13.
I'm sitting short pass over.
That's item 14. And this is a question petition which was not entertained by the High Court.
Rightly so. Application of public records. But you can't settle by compromise. Sorry.
And it is not at your sweet will. Someday you will do FIR and someday you will compromise.
May I say, my lords?
The property of a person, living person, was sold by showing him as dead.
My lords, it was first mutated.
Fabricated mutation entries.
Rightly, it's an offense against the society.
And the name and the parentage is same. My lords, the mutation officers, the tehsildars, the patwais.
You are not being convicted. Go and
later trial. On the objections, they reverted it, and then I entered into the compromise.
Nothing.
Yes. My lords, see, my lords,
we have seen. Both of us have seen, and we are on the same page. Yes.
The parentage was seen that created the confusion, my lords.
Yes. Have an opportunity of arguing on charge. Go there.
Yes, next.
Investigation is pending, my lords.
So, all right, it will charge.
Whenever charge sheet
convince the IO not to file a charge sheet. Thank you.
Item 46.
Well, 3.5 years this under trial has suffered, and both the two portfolio have not disclosed.
You had 7 antecedents. Stabbing, CCTV, eyewitness, everything is there.
But for 4 years he has been suffering. Only 4 witnesses have been examined. 25. Only 4 witnesses have been examined, my lords, in this case.
46 call.
Yes.
46.
14. I'm sorry.
Yes.
Just a minute.
Yes.
Oh, yeah, I see stabbing.
Your lordship may only hear me for 3 minutes.
Trial will be expedited, don't worry.
No, my lords, in 2020.
There is one deceased, one injured.
Stabbing, those
stabbing is a very cowardly offense.
Yes. Deceased and the injured witness is contradicting first
You
informant.
have 7 antecedents.
In fact, it seems first informant is involved. He was the rickshaw driver.
Sorry, dismissed.
Professor, your lordship may please hear me for 3 minutes.
Dismissed.
No, my only request, my lords, I may be heard.
So, you want an order on merits? Prejudicing the trial, please?
No, but at least
we are not convinced, Mr. Counsel. Bail is a matter of discretion, sorry.
My only request is that my submissions may be heard, my lord.
All right, we'll note your submissions then and deal with them. At this stage, you are inviting a conviction order. Do that.
My lords, in 2023, High Court had granted me liberty to move Sessions Court if trial is not progressed. I go before the Sessions Court. Sessions Court says, no, the matter should have gone before the High Court only. And then when I again move the High Court, there is again no discussion how long the
considering that there is evidence of eyewitness.
No, yes.
Injured eyewitness, CCTV footage.
No. My lords, I am not denying
against the petitioner who has allegedly stabbed the deceased on his abdomen.
Please have the statement of the
injured. Moreover, petitioner has 7 criminal antecedents to his credit. We are not inclined.
My lords, page 45, your lordship may.
We are not inclined to entertain this SLP accordingly. SLP is dismissed. Yes, next.
7.
My humble request, at least a report may be called from the trial.
Thank you. Over, it is over. Next.
7.
Item 47, it is for suspension of sentence and for grant of bail, Your Honor. Arrest order defective.
Dead body was recovered at your instance.
Grave offense.
Dead body was recovered at your instance.
No, Your Honor, but the only
for an early hearing of the appeal.
Previous
appearance, physical appearance.
This is a fresh matter. Lordship will have.
In 46, you are saying?
Yes.
Lilin. Yes,
very grave case.
Yes,
Your Honor, my CDR location was not found there.
You argue the
appeal.
Your Honor, kindly we will want to file additional documents. We
don't need, Mr. Counsel. These documents are sufficient to convince us.
Dismissed.
Item 48.
The Lordship, I have been under judicial custody since 9th of
Four weeks.
Lords, I appeal to the state, Lords.
Post on 11th March.
Lords, my
Yes.
appearance will be kindly taken.
11th
State of Bihar.
On 18th March. 18th to 19th March. Yes. Physical appearance.
Yes.
Physical appearance waives notice under test to file. Yes.
Lordship, in item 15, Lordship issued notice in last hearing. State has asked for time to file reply. But
yes, state. Pass over.
Yes. I need short accommodation, Lordship. I have
received some injury. I could not file it.
You are appearing in 15?
Yes, Lordship, I'm for the state. I received some injury. I couldn't file the counter. I'm instructed that there are several criminal antecedents against
1
this,
week or 2 weeks? What?
3 weeks, Lordship. Give me 3 weeks time, Lordship.
Why 3 weeks? 2 weeks.
Okay, Lordship. I'll file it. I'll file
2
it.
weeks for counseling.
16.
Yes.
Your Lordship, this is a case for extension of medical bail that was granted.
Any counter is filed?
No, Your Lordship.
The counter was filed against the bail application. No counter.
No, in this SLP, further extension is sought.
Yes.
And my lords,
You should place on record his current medical condition so that we decide.
my lords, I am representing the victims. This was a firecrackers factory blast that
We know. We have
I filed an impediment application 42645 that may be taken on record. I have also filed my reply, my lords. That may also kindly be taken on record.
This is an indulgence only on medical ground.
Yes. My lords, the challenge is I was heard by the Supreme Court. Even
When have you filed this impediment?
we have already filed, my lords. It's
Already means tomorrow, yesterday or day before?
Yesterday, my lord.
Yesterday it may not be.
But my lords, it has already been cleared by the registry. I have the
Come up.
Yes, very well, very well.
Deciding the matter today.
Yes, very well.
Yes. Let.
Did file the present status report.
Let.
And we also filed a reply, my lords.
Let respondent state of MP file counter affidavit mentioning the present medical status of the medical condition of the petitioner. Yes.
Your Lordship, at least my employment may be mentioned.
Yes. So and so learned counsel submits that she has filed
IA number 42645.
IA number
42645.
425 seeking impediment.
Along with the reply.
Let the impediment application be also posted for consideration on the next date of hearing.
Also, short date may be given.
Short date, what
Your Lordship, in the meanwhile, the interim may continue.
9th March. Interim bail. In the meanwhile, interim bail allowed in favor of petitioner shall continue till the next date of hearing. Yes. Yes. Yes, Mr.
There is the 164 statement of the girl. 183.
That is not.
He has already filed an affidavit.
The victim has already been of the claim.
The
father of the victim is here.
Yeah. He will also support. You are supporting?
High Court minutes, she has filed an affidavit.
All right.
Yes.
You are aware.
That medical report is also in mind.
Forget about medical report.
It is only for that. We impeded the father of the prosecutor so that we know whether at all
the affidavit was under
pressure. The affidavit was under pressure or it was free from pressure.
Yes.
Concede. We have heard the counsel, Mr. So and so, and counsel for the petitioner, Mr. Anand.
Yes.
The counsel for the petitioner and Mr. So and so for the state and Mr. So and so as well, appearing for the respondent number 3, father of the prosecutor.
Victim.
With the victim. Father of the victim. Pushto. Considering the entire fact situation of the case and the flip-flop
Item 18.
Your Lordship, I beg to appeal for petition, Lords. Lords, I was acquitted of the POCSO charges.
Yes.
I have been convicted under 3.
Where they were in relationship for 2020,
4 years.
2024.
Continuous romantic relationship.
Yes.
I'll leave it.
Same age group.
Yes, petitioner has been convicted. Leave granted. Petitioner has been convicted for committing offence under section 376 within bracket 2, within bracket small n on IPC and has been sentenced to undergo RI for 10 years. There is no conviction under POXO, no?
No.
Full stop. Under the impugn order, the High Court has refused to suspend the sentence and enlarge the petitioner on bail. However, considering the material on record, we are of the considered view that the present is a fit case for suspension of sentence imposed upon the petitioner and directing his release on bail. Accordingly, the impugn order is set aside. Criminal appeal is allowed, and the petitioner is directed to be released on bail pending appeal before the High Court. While suspending his sentence. The petitioner shall cooperate with the hearing of the appeal before the High Court. We are of the view, sentence पढ़ना
We are of the considered view वाला.
वो पूरा paragraph पढ़ना.
Accordingly, the impugn order is set aside, criminal appeal is allowed, and the petitioner is directed to be.
नहीं उसके पहले.
We are of the considered view that the present is a fit case for suspension.
Yes, of the considered view, on the length of jail sentence already suffered by the petitioner.
Lordship, may kindly
and other attending circumstances. Yes.
Lordship, may kindly record it was consensual relationship on the pretext of.
Oh, forget about it. You want a decision of the appeal at this stage? Let the High Court have its discretion.
Yes.
Great.
Well, there was some delay. There was some delay in filing there.
Delay.
Item 19.
Yes.
My lord, I am appealing for the state. We are seeking some time to file counter.
But complainant is you should implead complainant. Though you are enjoying interim order, we have granted.
Yes.
But since your statement was there that they have compromised. And he has received the entire amount. Implead the complaint so that he is here to confirm your statement. Let the complainant be made a party respondent in this SLP. Counter affidavit be filed and notice is issued to the complainant. Memo of parties be corrected. Whereas the United States Council is allowed 4 weeks time to file counter. Post the matter on 23rd March. Interim to continue.
Item 20.
Yes.
21 of this is a matter of
20. Yes.
There is not a single eyewitness of the alleged incident, my lord. But there is not a single eyewitness.
Not a single eyewitness.
Second, that motive is also not proved, and I am implicated only on the basis.
Antecedent, including 302.
Yes, only on that basis. Only on the basis of that antecedents I am implicated in the matter. The second aspect of the matter is that that
CCTV is there. You were roaming around.
So 20,000.
What is the distance between the place of occurrence and the toll plaza?
That distance?
Yes.
That distance, Lord, I am not aware about that.
You have to make a statement on that.
But that second aspect of the matter is this. Only on the basis of antecedent, the police authority implicated me in the present matter. I was taken into custody on 5/8 on the basis of that CCTV footage, and that produced me after on 9th. The remand report is very much clear. That is the another aspect of the matter.
What is the remand report?
Remand report said that on the basis I was moving suspicious on the toll plaza.
Where is the remand application?
Page 41 is 39 starts, my lord.
Yes. What do you want to read from that?
41 second paragraph, my lord. While local police crime branch so and so, and we along with our subordinate police staff were investigating the said crime, an individual named petitioner was seen under suspicious circumstances on a motorcycle on 5/8 near the tea stall at the toll plaza on the way from Pune to Nashik. Upon further questioning, he gave evasive answers. As suspicious grew, he was taken into custody and brought to the police.
On 9th.
Taken into custody on 9th.
They are showing that on the arrest form, my lord, they
9th August.
Yes, 9th August. But I was taken into custody on 5.
So it's a case of 4 days illegal custody.
Yes.
Lord, he was not taken into custody on 5th.
Oh,
Lord.
he was confined on what ground for 4 days? Did you release him?
Lord, he was taken into custody on 9th, not 5th.
Read page 41, Mr. Counsel.
41 says
when did you release him?
Not arrested.
Detention is on 5th August. You continue to keep him confined for 4 days.
Lord, this says on 5th. On the basis of CCTV, he was moving around that
was
on 5th.
detained. Read please page 41.
While the local crime branch, Ahmednagar, and we, along with the subordinate police staff, were investigating the said crime, an individual named Bhushan Wale was seen under suspicious circumstances on motorcycle on 5th so-and-so at 3:30 am near a tea stall at Toll Plaza on the way from Pune to Nasik. Upon further questioning, he gave evasive answers. As suspicion grew, he was taken into custody and brought to the police station. Upon questioning him in confidence, he confessed to
What is this date? He was taken into custody.
When was he brought
What
into
is this
the
date?
police station?
Lord,
So from 5th August to 9th August, they have taken a specific ground.
Lord,
What have you replied?
Lord, as per my Lord instructions, my Lord, he
Does this document read that he was released thereafter and was asked to come
You
back on 9th?
satisfy us that he was taken into custody on 9th itself and not on 5th.
The document itself reads so. Where is your ground, Mr. Counsel? To this effect that he was kept in illegal custody.
Yes, page 4 of the inquiry note.
Yes.
Para 4.
Yes.
Learned advocate for the appellant submits that.
What is your reply to this?
Non-communication of grounds of arrest for 4 days.
Yes.
Yes.
Lord, I have stated that he is taken into custody on 9th itself.
What were you doing with him since 5th to 9th, Mr. Counsel? That's what we are asking. How was he kept confined for 4 days without preparing an arrest memo?
Yes, what has...
But he was not confined. He was arrested on 9th itself. Lord.
What were you doing with him from 5th? Please, your document remand
It is
form says...
specifically, page C, last paragraph, petitioner was taken into custody on 5/8. What is your reply to this? Because the remand was taken on 10/8. That means he was arrested on 9/8.
Arrest memo itself is
From 5th to 9th,
he was in illegal
he was in
custody.
illegal custody. And you have not replied to this specific...
And grounds of arrest? Nothing.
Lordship grants me a week stand.
No question. No question. Sorry.
Take. Heard and counsel for the parties. Considering the material on record, and for the fact that petitioner is in custody for more than 1.5 years, we are inclined to release the petition on bail. Accordingly allowed.
Great.
Seeking a short passover in this matter, Your Lordship. We are led by Senior V. Giri. Please on left.
Yes.
Passover.
Passover.
Item 22.
It's point 2 to 4.
Yes.
Made. Sorry. Because while issuing notice, please see the order which has been passed. Okay. 29-4.
You want to argue? Come on merits.
No, on merits only, my lord.
Yes.
On merits. Please come to the order.
No, you convince us.
Just 1 minute.
You are a developer.
No, my lord. I'm the original owner. Please come to 29-4 for a minute, my lord. My lord's order. It is the contention.
You will not argue.
No, I'm arguing, my lord. Yes. It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years. Delay condoned, issue notice, etc. Now, it was my specific, my lords have the 29-4 order.
Yes.
Now, it was my specific case before the High Court that the award was 2 years beyond the Section 6 declaration. And therefore, the whole thing lapsed under Section 11 capital A. Specific ground was taken. No specific answer for that issue. In fact, that ground, if my lords will see, is that in the writ petition.
Which order you read?
29-4, 2024 of my lords, while issuing notice.
Again, आरोपी नहीं है.
Yes.
May I pass on?
Yes. अच्छा आगे पीछे लग गया.
First parameter. It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years, delay, condoned, issue notice, etc. Now, this ground was specifically taken in the writ petition. Please come to writ petition at 99, specifically the grounds at 108. Please come to that for a minute, my lords. 99 it starts. Act, my lords, 108, para 16. Bottom of para 16, award notice, last line, my lords, last 3 lines in fact.
Yes.
Is also defective and the award is passed beyond stipulated period of 2 years, which again is contrary to 11 capital A of the Act. Now, apart from this,
what is their answer to this?
No specific answer to this.
Let us see the counter first.
Yes.
The writ petition.
Yes. Now, please.
Because the High Court has not dealt with this.
It has not. That's why, my lords, we specifically pointed it out. One more aspect. I also raised the ground that the time period between 4 and 6 also there is a delay. That is taken note of by the High Court and they deal with that. Now, please come to page, the impugned order, page 23. It is to be noted, last paragraph. It is to be noted that no other ground is urged seriously, but on going through the learned single judge's order, the petitioner has taken a contention that the final notification is not published within the time prescribed. Single judge has considered the same at para 10 of the order, taking note of the fact that the publication at Satur village by the revenue inspector is on 16/12/2010 and final notification is on 15/12/2011 and rightly held that the final declaration is within the time prescribed. So of the 2 points raised by me, the first point with regard to 4 and 6 is looked at. Now, please see what they say in the counter before my lords in respect of this point. Please come to that. For the first time, a document has been produced and High Court has really not looked at it. And we have not had the opportunity to rebut it. Therefore, perhaps appropriately, it may be a case to go back to the High Court.
Not go back. We'll decide here itself. You file your reply to this. If they have filed it now,
yes,
you can file additional affidavit.
Sorry to interrupt. May I just point
out? I want to point out something.
I'll answer on merits. It's covered by your lordship's judgment, but this is not even a ground raised in the SLP. Although because it was there in the notice, order issuing notice, we have referred to that. The single judge, my lords, refers to this argument. Page 151 rejects this argument. Before the division bench, it appears to have not even been raised. In the SLP, in the grounds, not a single ground on this. While issuing notice, they appear to have taken this. Please have page 151 first. And covered by your lordship's judgment. I'd show the judgment straight away.
Can I then point out their objections before the High Court?
Page 150, bottom of the...
If you wish to file any additional affidavit,
there is a specific ground. I will file, my lord.
Otherwise, don't waste time and then after 10 minutes you will say, allow us time.
Very good. We'll do that. I'll do that.
Your lordship is referring to page 23.
Wait a minute.
In view of the additional document filed by respondent, the learned senior counsel appearing for the petitioner seeks time to file additional affidavit. Accordingly, post the matter after 4 weeks.
We'll do that.
Post the matter on 10th March. Sorry, 19th March.
I'm sorry, is there anyway? That ground is there anyway? I'll show your lordship. It's covered.
I didn't want to say anything.
It's covered by your lordship's judgment. May I make one request, though, my lords?
May be covered, but since he will seek time after half an hour, we know.
May I then make
one request?
This entire project of about 250 houses is stalled because of this. 2,500 houses is stalled because of the stay.
We'll hear it next.
Some date, if your lordship's.
Date already given, 19th March.
Yes. I'm reserving myself on the last submission also, my lords. We are disputing it. Anyway, my lords, I'll file my affidavit and we'll argue, my lords. Leave your obliged.
My lords, permit me to submit hard copy of the appearance, my lords, for item 22.
Why hard copy?
My lord's names of two of the councils. My lord's name of one of the seniors, my lord's was missed on my part, and the application. So,
Item 23.
Yes.
Hello, Santosh Kumar had received on 13/8/2019 suicide note.
Where is the suicide note?
As per the suicide note, my lord.
Lord, sir, we have